All right, we're now live streaming. Welcome, everyone. It's Friday, February 18th. Welcome to JPR voting session. How many bills do we have on? A lot of bills. All right. We're going to start off with the withdrawn bills. We have 3 bills at the top that have been withdrawn. So we'll start off with Senate Bill 546, Senator Lamb, that's been withdrawn. The motion's for an unfavorable withdrawn. Is everyone okay with that?
Yep.
All right, excellent. Next up is Senate Bill 605, Senator West. Motion, it's been withdrawn. Motion's for an unfavorable withdrawn. Is everyone okay with that?
Yep.
Yes. All right, next up is Senator Watson, Senate Bill 730. It's been withdrawn. Motion's for unfavorable withdrawn. Is everyone okay with that?
Yep.
Excellent. All right, we'll now start off with, since we're one member down, we'll start off with Senate Bill 161, Senator West. We'll have counsel explain, and then Senator West, if you want to chime in.
Hey, so this bill holds indemnification and duty to defend provisions in certain contracts void. So first, it prohibits the inclusion of indemnification provisions in contracts with a design professional for professional services unless the design professional is the proximate cause of the damage. It also prohibits any clause requiring the design professional to defend a promisee and other parties against liability for claims for damages alleged to be caused by the design professional's negligence. There is one amendment in your packet. The amendment on page 3 of the bill, line 31, it changes the proximate to a proximate cause. And then on page 4 of the bill, it strikes paragraph 6 in its entirety.
Thank you, Mr. Chair. This bill is the top priority of the state's architects and engineers. Right now, they are having to pay for injuries to people that weren't their fault in any way. I gave the example of the concrete mixer backing up in a construction site and knocking over some steel, and it injures someone. The architect wasn't responsible for that. The engineer wasn't responsible for that. But under this provision, the architect or the engineer can be held responsible and forced to pay all the damages. It's unfair. It's just wrong. So I move favorable.
Let's go ahead and adopt the amendment so we can work off of that. Before that we can continue the discussion. So is everyone, can we just adopt the amendment first? Is that okay? Understood. Okay, she's got a question on the amendment.
What does striking this number 6 do?
So one of the written testimony, it stated that paragraph 6 didn't make logical sense because it could be interpreted as some of these provisions are still valid, so it could cause confusion. So I think it's more of a clarification.
Okay, thank you.
All right. So, motion to adopt the amendment. Everyone's okay? Second? Good. All right. Senator West, okay. Do you have anything else to say?
All right. I move favorable.
Further discussion. There's been a motion.
Second.
It's been seconded. Is further discussion? Do we need a roll call? Is everyone okay? All right. Passes unanimously with amendment. Next is Josh with Senate Bill, let's go 232. And then Heather, you're up next with Senate Bill 279, okay?
This bill increases the maximum salary that the Board of Public Works may set for a Register of Wills from $124,500 to $146,500. Because of constitutional requirements, the increases could only take effect at the beginning of the next term of office.
All right, there's been a motion for a favorable. It's been seconded. Everyone okay?
Yep.
All right, excellent. Bill passes unanimously. All right, Senate Bill 279, and then on deck, Jamie will do 286 next. Okay.
Oh, weird. So Senate Bill 279, this bill alters the contents of the Access to Counsel Eviction Special Fund. So if money is received by the Division of Consumer Protection from a settlement agreement with the judgment against a party for in relation to an investigation or enforcement of consumer protection, that money will be transferred into the fund. There is one amendment in your packet. The amendment strikes the last whereas clause on page 2, so that's lines 6 and 8 of the bill. And also, the amendment specifies that money that is transferred to the fund must be from a final judgment.
Yes, please.
All right, excellent. So we'll, motions to adopt the amendment, seconded, great, everyone's good. Further discussion? Sure, Senator Castley.
We get these bills, and I just, just as a matter of policy, if, why doesn't this money just go into the general fund and then it gets allocated out every year? And if there's a surplus, it stays in the general fund of that. If there's not, you make it up from something else. But if something's worth funding, you fund it to that amount, they have a budget, and they don't just get to spend whatever comes in. They operate like everybody else in the state does. I just don't understand. We keep seeing these earmarking fines and the like. It just seems like a backwards way to do governance.
Well, we've made the decision as policymakers that there are some settlements that the state receives that are best directed to the relevancy. For example, the opioid restitution fund and the cigarette restitution fund. So tobacco settlement and the opioid manufacturers, we have done that there. With regard to substance abuse, funds are directed from the opioid settlement fund there, and education and prevention work. Same thing with regard to tobacco, smoking cessation and education. And here, these are institutions that have done wrong. And it's entirely relevant to be able to take the proceeds that the state receives and direct them into also a relevant fund that will help both landlords and tenants, actually.
I get that, but if we, in a normal budgeting process, you would say, how many lawyers can we afford this year? And that's what you fund. What this says is, we'll fund as many lawyers as how much money we get from the restitution fund. We'll front load all that, you'll hire, eventually that runs out, and then you're back down to not having enough people to assist. It seems like a more sustainable and logical approach would be that we don't spend as much as we get, that if the need is $50 million, but the fund has $200 million, you don't throw that all into the fund, what you're trying to fund, you put it in the general fund, and you have a budget every year, you go before finance, you make your calls like everybody else does, and then you have to justify yourself and show your progress, and then if you don't, then your budget's reduced. But this basically, to my view, takes this fund out of good governance, basic good governance, that you have to come in and justify your budget, where they just say, well, hey, we can spend everything we get.
My response would be if there were money in the budget that were directed to the Access to Counsel Fund, we wouldn't have to do this. So
Well, then it's just
it
not
is not,
appropriate for JPR to do then. Okay.
well,
It's just a matter of philosophy. I'm just not going to support, to me, this is just, we continue to do this as bad governance. Monies ought to go into the general fund and be allocated out to programs based upon the priorities that, I mean, this fund looks important in this bill, but if you compare this fund to all the other needs next budget year, or even this budget year, which we don't see, I have no idea where it stacks up. I mean, is there a fund out there that's actually more important than this? A program that we're shortchanging. So when we do this, we don't really look at things holistically. You look at one piece, you throw all the money into it, and then you look at everything else. It's not a good way to do governance. So, but I appreciate what you want, Senator. Thank you.
So I do have a question about the opioid restitution fund, and especially and the cigarette restitution fund. I know in my district, I have a tremendous amount of people that are suffering from opioid addiction. And one of the toughest things we have to do with the budget is to be able to get money to address those issues. Is the money that's coming out for this, is that going to be competing against the money that we would be able to pay and help people that are addicted? What's that?
Absolutely not. No, this is a separate fund, totally separate from that. I'm just using that as an example, as a precedent that we have done. The Attorney General has defended or has sued opioid manufacturers, and there's a special fund that this body created to direct those proceeds to help your constituents and our constituents who have to deal with opioid addiction. Same thing with the cigarette restitution fund. The big settlements that are coming from the tobacco companies, same thing, education, prevention. This is just a separate fund. Doesn't have anything to do with the others, other than those are the models that we base this on. So these are bad actors who have been in the community and done, engaged in abusive practices and landlord-tenant issues. And so it seems equally relevant that the proceeds from those settlements should go to people to assist them in landlord-tenant issues. Solely as a model, that's it. No mixing of money.
So that's so the example in the preamble that they use for both of those is just for an example purpose?
Correct.
Okay.
Senator makes a good argument. I know it's kind of you're right, it's not a budget, a line item in the budget, for both reasons. That argument cuts both ways. It's not there, and, maybe that would be the more strategic way to do budgeting in general, but you need willing participants to make it happen. And you're right, there are other funds that have a direct nexus to the activity, so I'm fine with it. If there are no further discussion, I'll make a motion for a favorable.
Second.
We can do a roll call. What? Is there something going on? Favorable with amendment, yes, yeah.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly. Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes, if I can be a co-sponsor. Yes. Yeah, I like it.
Heather. Sorry. Senator Watson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. Six. And then we're gonna do 338, and then we're gonna go to Susan Lee.
Senate Bill 286. This bill provides that a person may not be denied the right to purchase, possess, or carry a firearm solely on the basis that the person is authorized to use medical cannabis. This bill passed the Senate last year, 45-0 on the Senate floor.
No. There are no amendment.
It was amended. Sorry, it was amended over in the House, and provisions for unserialized or untraceable firearms were put on it over in the House, so it didn't move once it came back over.
Yes, they did me a nice favor. They were being political. They threw the ghost gun, they got rid of my bill and threw the ghost gun bill on there. It was like, had nothing to do with this bill or the merits of it.
Yeah.
Yes, it's almost, it's humorous, yes.
I mean, you gotta laugh a little bit. All right, all right, so the motion's for a favorable, there are no amendments. It's been seconded, is everyone okay? All right, great. We'll go on to Senate Bill 338.
Senate Bill 338 authorizes a person to apply for preliminary approval of a permit to wear, carry, or transport a handgun without completing the required firearms training course, subject to specified requirements. Essentially, how this would work is that a person would apply to state police for the preliminary approval to get the permit. The permit wouldn't actually be given to them until they had completed the training requirements, but that preliminary approval would give them an indication as to whether or not they were eligible for the permit.
I think this will be obviously this is my last try with this, but it's year number 4 at least with this bill. So it's a no-brainer.
I'm pretty sure we passed this bill unanimously on the floor and in the committee. So no amendments, motions were favorable. It's been seconded. Is everyone okay? All right. Let's do, Heather, can we do Senate Bill 280?
So Senate Bill 280, there is an amendment in your packet that strikes the bill in its entirety. So as it was introduced, the bill dealt with interim and temporary protective orders for electronic filing at a hospital. So the amendment strikes the bill in its entirety, and so for electronic filing, a petitioner may file a temporary protective order, not dealing with interim anymore, electronically, while the petitioner is at a hospital receiving medical treatment or from certain assistance programs or centers that are listed in the bill, like a domestic violence prevention or assistance program or a sexual assault prevention or assistance program. The bill also requires the court to hold the temporary protective order hearing virtually, either if it's filed during that business day, or if it's filed after hours at the next business day that the court is operational. And lastly, the bill states that if a petitioner filed a temporary protective order at a hospital, under the amendment, the hospital would be required to refer the petitioner to a domestic violence program or sexual assault program. It just says.
Thank you. Just a question that just popped into my mind. So the ability to file electronically, since Baltimore City, for example, isn't up on MDEC and we don't yet have electronic filing for anything, this would not even pertain to Baltimore City yet until that happens. Is that correct? It's not possible. We don't have electronic, we don't have MDEC. We still have paper filing.
So my understanding is that it wouldn't be able to be possible anywhere yet because the systems aren't in place. But that is something that the judiciary is going to work on. So that's correct.
Thank you. And how would this impact notification to the respondent?
I don't think it impacts it in any way whatsoever. This is just the first part, right? This is just the ex parte part. And so that decision comes after that hearing. So there's no change in that at all.
Interim, I thought.
This is temporary. This is
Okay.
just temporary.
Thinking about the bill and now the amendment might make it better, I guess. I don't know. But I get the reason that we would allow it from a hospital or if someone is receiving care, but what is the reason that we would allow it from these other locations if the person is physically able to do it?
There are two reasons. One is for some of the same reasons why we might allow it from a hospital, that people are more comfortable doing it and are scared to go down to the courthouse, and so they're more comfortable being supported if they're going to a domestic violence program to seek help, or if they're going to an elder abuse program to seek help, or a child abuse program. So it is also having the support to be able to complete the application to do so. So for some of the same exact reasons why they might at a hospital. Obviously, if they're at a hospital, they're seeking medical care, and sometimes people disclose at a hospital, whereas they might not at other places. But we feel like by limiting it to these places, there are people who are seeking help and assistance, and they will be able to get them at those places.
Okay. hearing. And, I don't have a problem with allowing electronic filing. That's not an issue. I do have some modicum of concern about the opening up for the potential of coercion and over-assistance. Because these are supposed to be situations where someone's been abused or violated and they're seeking help. They may not understand the process, and then someone can explain to them, well, you have the ability, usually police officers explain, you can go down, police officers even escort people if they're free to go to file a protective order. I guess my concern is now you have these experts there to, I don't know what the limitation is on the ability to assist. And I asked this at the hearing, and the answer was they wouldn't be doing anything, but, I don't want other people, third parties, filling these forms out for people.
Absolutely. So I
Because
totally,
in all fairness, the respondent gets no help, no services at all. They don't get an automatic attorney when they go to court, as the complainants do, in Baltimore at least.
So two things. One is you still, the complainant has to file it themselves. No one can file on anybody else's behalf. They still have to complete the form and sign the form and do that themselves. They do get assistance, and they do still get assistance if they go to the courthouse. Frankly, one of the concerns of Judge Morrissey is that when we initially started to talk to him about this, is that people would be doing it on their own and wouldn't have the assistance and wouldn't have the support in being able to complete the form. And so that's partially where the link with the programs came from. But no, I hear what you're saying, and this is 100% about the person filing themselves and getting the information from, the supporters that they need. But they have to do it themselves.
Thank you, Mr. Chair. This just responds to Senator Carter's initial question. The language, as I read it, says may. So this would not preclude someone in Baltimore City from filing in the old-fashioned way with paper. But where there's possibility of the court receiving electronic filing, this enables the person in the hospital to do it that way.
One other thing to add is this is being done in Montgomery County at the Family Justice Center. It has been doing, it's been in operation for a few years. So they have worked this out, and it seems to be working quite well there.
Yeah, Senator Edelman, isn't this a useful way for a victim of domestic violence or human or labor trafficking or sexual assault to do this? They're usually trying to escape their abusers or traffickers, and they're able to do this at these centers. In a case of a child abuse and neglect, they could also do it there. And also a vulnerable adult, same thing. And where otherwise they may not have been able to do it because they're so afraid to step out without being a fear of getting killed or maimed or murdered or injured.
So first, let's go ahead and, we'll adopt the amendment. Is everyone okay with that? All right, which is what we've been discussing the last 10 minutes. Further discussion. Sir, Senator Castley.
I'm fine with the bill. I'm just looking to make sure it says what we want it to say. On page 2 of the reprint, section C, a petitioner may file electronically a petition for a temporary protective order with the court from. So, and it says from a domestic violence prevention or assistance program. I just don't know. I'm not really sure what that means, because with the court from, you're filing it from the computer. I don't know what it means to file it from a domestic violence prevention or assistance program. I don't share Senator Carter's concerns about people helping. That's how these are done normally now. SARC takes people in groups like that and sit them down and help them through the form. A lot of times they can't. Their writing skills really suck and things like that. So they provide them assistance so it makes sense and it's legally correct. It'd be maybe appeal to counsel on that. With an order from, it's not going to say on the petition that you're with the person helping you to fill this out is from a sexual assault prevention assistance program. So how does that even become relevant? If all the court's going to get is a form filled out, it's got to be signed by the petitioner, and if her grandmother helped her or SARC or the guy in the hallway, it's kind of irrelevant as long as she signed it. So I'm not sure what we're doing with that section.
Section C, these are the locations where they can file a petition. So the petitioner couldn't file the TPO from their apartment. It would have to be at the Domestic Violence Prevention or Assistance Program. I do see what you're saying, because it doesn't, because a child advocacy center, that's a physical location, whereas a domestic violence prevention or assistance program, that's not, it's more of like the name, not the center. So I think I could work with Senator Hedelman to reword it to make it clear that it's the location where the domestic violence prevention or assistance program is.
I mean, if I look at the first part of this, we're filing it from her hospital, and it's a good chance we're filing it from her hospital room, or,
So yes, B1, that's the petitioner may file it from the hospital, period. Petitioner 2 is also seeking a TPO, but goes to a domestic violence prevention or assistance program, their physical location, wherever that location is, not a hospital. From that location, the petitioner can file the electronic petition. Petitioner 3 wants to file it electronically from their apartment. You can't do that under this bill. It has to be the hospital or these specific locations listed under C.
but, so once you have MDEC, I guess most people, only lawyers usually use MDEC, but, well, it doesn't include the lawyer's office, so that's.
No, it doesn't.
I mean, if I have a client who's filing and she's in my law office, I can file that on MDEC, but it may not be legal because it
No,
doesn't.
you won't be able to.
But that doesn't make sense then.
Well, we really
She's
wanted
receiving
to.
medical treatment.
Part of the point of this was to link the person, the victim with services, right? So to make sure that they knew what the services were. And these are places, the hospital, the domestic violence program, the child abuse program, the human trafficking program, the elder abuse program, that they could go to for help. So we really wanted to keep it pretty tight and narrow to be able to connect them with services. So we didn't want them, some states have done this, like they have it, at the 7-Eleven or whatever, they would have a kiosk set up. We really wanted to connect it with services, so that the person who was going through this and was being victimized was connected with other services and could get more easily legal protection.
But aren't what we're doing here is saying you can't use your lawyer's office to file electronically a petition for?
It doesn't say you can, it says this is a separate, these are the only places, right now, the only place you can do is, the only place you can get a protection order, with the exception of Montgomery County, is to go down to the courthouse to put in your paper, right? This is now broadening that to say you can do it electronically from these places also. You can also go down to the courthouse in person, but we're going to have an electronic system now where you can go to the hospital, you can go to Turnaround, which is a program that provides services to human trafficking victims, sexual assault victims. You can go to the House of Ruth and other community-based programs that provide child abuse programming, elder abuse programming, human trafficking program, and that's it. Does that clarify?
Yeah, I mean, I see what you're trying to do. It's just that I'm concerned that once we go with, everything's moving towards electronically filed. Even your landlord-tenant's going to go there eventually. And I wouldn't want to preclude women from relying on their lawyers.
That's next year. This isn't,
Well-
maybe, but this is,
It's just that a lot of lawyers do reduce fee stuff for domestic violence people or even pro bono. Our county has a really robust pro bono program, and they'll just say, hey, Attorney Jones has agreed to represent you in this, go see him, and he'll file it for you. That's not uncommon at all. Even like if you have SARC, because, SARC doesn't have they need help, so they'll just refer the woman to a pro bono attorney. I just wouldn't want to.
I hear you.
concerned about limiting
Honestly,
it.
we hadn't thought about broadening it quite that far. We really wanted to keep it
There
pretty.
could be a catch-all or any other location approved by the court, by the courts or something, and that way we don't keep amending this because the court can approve it.
I'm okay with that. I mean,
I like the idea that right now, because you're connecting with actual services, like there's like a wraparound feel to it, but I see what you're saying. I mean, I see what you're saying, Senator Gasly, but I don't know, like, have we explored that, or like, I mean, I don't even know, like, what are the unintended, I don't know. But I get what you're saying.
I mean, in my county, I had a 2-year, I represented all the domestic violence victims that were not on a contract with SARC. They came to my office. I would file a petition on a reduced fee but it wasn't paid by the victims. It was always paid by the grant to SARC. I represented, 1 or 2 a week, every week for like 2 years. They would go to SARC, but then they would come to me. I would file the stuff, so. I just wouldn't want to interfere with the counties that have that kind of a program.
Yeah, I mean, to be honest, we just hadn't thought about going that broad. I mean, it's an interesting, it's a very interesting proposal.
I mean, here's the deal. I mean, we've got.
What about line 6, if you have 6 or such other location approved by the court?
I'm okay with that.
If you're okay with, I mean, okay. I want to get Senator Bailey in here, and then I got a couple questions. Go ahead.
So I have a question concerning when these are filed in person, if somebody filed one fraudulently in person, the court and the law is can address that, right? That would be a false report.
You have a hearing. You have an ex parte hearing, just like I go down and I file and I have a hearing. Same thing would happen here.
No, I do understand the process. If they had filed that in person and they made it up and caused that hearing because they filed it in person, then that would in fact be a crime. My question is, if they file it, what do we have, and maybe the attorneys can help us with this, but if they made it up and they did it electronically, does that carry the same weight if it was done illegally, if they made it up, as it did if they were in
It's still
person?
going to be a crime because at that ex parte hearing, they're going to put the witness, they're going to put her under oath, and the judge is she's going to verify that she signed that, and those are her allegations. And it's just like all the other, I mean, we're doing district court trials, video constantly now in all kind of civil matters. And they swear the witnesses in, and you're videoed. And
That's at the trial.
yeah, well, this is a trial. I mean, these hearings are.
I'm talking about the complaint to get to the trial. Is that in fact a crime if that is done over the video that way? And if it is, that's fine. It's just a question.
This bill does not impact that at all. Like, if the penalty for falsely filing a petition for a protective order would remain exactly the same, this bill doesn't impact that.
So what do you want to do with the Cassie?
Amendment number 6 on page 2 of the reprint, so it'd be C6, comma after 5, or such other location as approved by the court. So we don't have to come back. So those counties that were like, the smaller counties where you just panel everything out, don't get in trouble with this.
All right, we could adopt that amendment? All right. All right. Now the bill's before you as amended, and further discussion? Motions for a favorable? With amendments. It's been seconded. Is everyone okay? All right, passing unanimously, as amended. All right. We go on with, we're gonna go Senate Bill 328. Sorry, what?
Senator Jackson also requested to be a co-sponsor.
We can make that, it's fine. Is everyone okay with that? Senator Jackson wants to be on there? Okay. The bill we just, yeah. Senator Lee wants to be on there. All right, we're now at Senate Bill 328.
Senate Bill 328 alters the definition of stalking to include conduct that occurs in person by electronic communication or through the use of a device that can pinpoint or track the location of another without the person's knowledge or consent. There is a technical amendment in your voting packet. Going to the reprint, on page 2 in line 9, would just provide, stalking includes conduct described in item 1 of this subsection that occurs in person by electronic communication or through the use of a device that can pinpoint or track location. And as follows.
Amendment's been adopted. Now the bill's before you as amended. Further, motion for favorable, it's been seconded. With amendment. Everyone's good? All right, great.
Is it too late for me to ask to be added as a co-sponsor for Senator Huff's 2 bills?
You can go ahead. Yeah, we can do that. Held it, then we'll make floor amendments, it's fine. All right. We'll just do floor amendments. First, we'll just do a floor amendment for that. Okay. Okay, so I want to tack back to the, since we just did his stalking bill, we can do Senator Lee's bill, yeah. Yes. So we go Jamie, and then
Just pull that up. So Senate Bill 134 requires the Maryland Police Training and Standards Commission to require for entrance-level police training and at least every 3 years for in-service level police training conducted by the state in each county and municipal police training school, that the curriculum and minimum courses of study include special training, attention to, and study of the application and enforcement of criminal laws concerning stalking as they pertain to electronic surveillance or tracking, including services available to victims, related prevention methods for victims, and how to document digital evidence. There is one amendment in your voting packet.
Can we get Senator Lee on? Oh, hold on, just Jim. Do you want him to explain the amendment first, or do you want to? Oh, all right.
So the amendment in your voting packet is for SB 134, amendment number 883-623/1. It strikes on page 2 of the reprint the reference to documenting digital evidence and provides that the training would need to be for the criminal laws concerning stalking as they pertain to electronic surveillance or tracking, including services available to victims, related prevention methods for victims, and how victims may request additional assistance to identify and preserve digital evidence. It seemed that based on information that was submitted to the committee as well as the testimony during the bill hearing that there was I think a disconnect between what advocates on the side of the bill providing for training believed that would be required, and also what law enforcement thought was required by the bill. Information provided by, I believe it was a representative of the Electronic Frontier Foundation, suggested that this training could be done in an afternoon or a couple of hours. And it seemed that there was some concern from law enforcement that the requirement to do training on the preservation of digital evidence could be more specified training that would be a little bit more costly. So I believe this is trying to address that, and instead of requiring officers to be trained on how to preserve the digital evidence, it requires them to be trained on where they can direct victims to request additional assistance to identify and preserve digital evidence.
Senator Lee.
And we had heard from Wayne Silver, who's executive director of the commission that does the training, that they're okay with this bill and that they can do the training very easily. And I believe the amendments that we've made address the concerns of the police. And this bill complements the bill we just presided over. Because the police need to know what they're looking for when they are trying to assist a victim of electronic stalking.
The amendments are adopted favorably. Everyone's good with that? All right. Additional discussion.
Looks like that takes care of
The fiscal, yeah.
Yes.
Yeah. All right, so this motion for a favorable with amendment. It's been seconded. Everyone's good? All right, rock and roll. Let's go back to Senator, sorry, Josh, I didn't give you the heads up on this, but Senator Waldstreicher, Senate Bill 317.
Senate Bill 317 raises the maximum fee that can be charged for notarial acts. For an in-person notarial act, it raises it from $4 to $25. For a remote act, from $4 to $50. It also clarifies the requirements for remote notarizations, and it repeals a prohibition on remotely notarizing wills, which I would just quickly note for the committee. An identical change is made by Senate Bill 36, which is also on the list for today, so just be aware that the two bills are identical in that portion.
So this is a miscellaneous bill that cleans up the law relating to notaries and makes it clear that remote notarizations are permissible in Maryland.
No amendments, nothing? All right. So. I was wondering, I was looking over there. Got it, okay. So motions for a favorable. It's been seconded. Is everyone okay? All right, the bill passes unanimously. All right, great. Let's do. Yes, Senator West. Let's go. Let's clean up your bills then. Let's go ahead and go to Senate Bill 49.
Senate Bill 36 is an emergency bill, which is a follow-up to Chapter 686 of last year, which authorized the remote execution of wills. But due to an oversight, that process is currently not functioning because it required remotely executed wills to be notarized. But as mentioned on Senate Bill 317, that notary statute actually prohibits the remote notarization of wills. So this bill would do two things. First, it would do something which was also done in Senate Bill 317, which was just voted favorably, which was remove that prohibition. But Senate Bill 36 would additionally allow an alternative procedure for executing remote wills, which does not require notarization.
Yes, the second part of this, which is different from the bill we just passed, allows a notary, well, normally we have to be three people in the room while the will is signed. A notary and two witnesses. This bill provides that you don't have to have a notary, but you still have to have three people in the room, one of whom has to be the supervising attorney who will execute the same attestation that the notary would have executed.
No amendments, right? Okay. Discussion? All right, motions for favorable. Seconded. Everyone's good? Excellent. All right, let's move to Senate Bill 74. So we just,
We didn't do 74. This bill increases the maximum annual salary the Board of Public Works may set for the clerks of each circuit court from $124,500 to $146,500. There are no amendments.
approval from B&T, right? Okay, so motions for a favorable. It's been seconded. Everyone's good? Great. All right, Senator West, let's go to Senate Bill 49, and then we're going to go to Senate Bill 20.
Senate Bill 49 expands the definition of a person in a position of authority under the fourth-degree sex offense statute. The bill also expands application of the fourth-degree sex offense statute to include certain individuals. Lastly, the bill establishes that unless specifically charged by the state, a violation of the fourth-degree sex offense statute cannot be a lesser included offense of any other crime. There is an amendment in your voting packet. This is number 593026/1. It creates a carve-out to provide that the person in a position of authority does not include an individual who is under the age of 23, enrolled full-time at a college, university, institution of post-secondary education or post-secondary vocational, technical, or trade school, and is supervising a minor who is 16 or 17 and also enrolled full-time at the same college, university, institution, post-secondary education, et cetera, as the supervising individual. It also strikes provisions of the bill that would have applied to individuals who had previously had that supervisor and person being supervised relationship, but no longer do. And that's my explanation.
Yes, this came before us once before. We had a nice work group in my office. Senator Hedelman was there, Senator Huff was there, and Delegate Love was there. And we came up with this amendment to solve the problems. So I moved the amendment and then moved favorably that we adopt the bill.
Child care facility.
What did we strike? What?
Child care facility. Why was that? Why, or after an after-school program?
Where's that?
It's on page 2 of the reprint.
Well, I think what we were discussing, is that at least there was discussion that I don't know the likelihood of this happening at a child care facility because you're talking about minors who are very young there and older people. No, it would not fall into this person in position of authority because you're talking about, that's sex abuse of a minor.
There's another example, but go ahead.
But that's at least why I think that might have been taken out.
Oh, so I gave it the example, I don't know that I support taking that out. So here is the example. There's a preschool program that is run across the street from a high school. This is in my district, and there are kids who go and volunteer after school at this preschool program. And so I wouldn't want one of those kids who's under the supervision of somebody who's running the preschool program to be, that's exactly, I think, what this is describing. So I would like to put that back in.
You're saying that you don't want the teenager to have sex with the supervisor?
The supervisor, right, to be prowling
On the, got it.
right? That's sort of the hypo here.
let's go ahead, let's adopt the amendment first, and then work off of the amendment, so we can not amend a hypothetical amendment that's not there yet. So, all right, we adopt the amendment, everyone's fine, great, okay.
What's that? Yeah. The other change, it says does not include an individual who is under the age of 23 years, enrolled full-time at a college, university, who's supervising someone 16, 17 years old, and who's also enrolled at the same college, university, institution, post-secondary education. I mean, it's just sort of an interesting, it's sort of an elitist amendment that says, if you're not a college kid, yeah, you're screwed. But if you're a college kid and you're picking on college kids, then you got a special license to kill. It's like the 007 thing. I mean, if the law is the law, why would it matter if your relationship is in college or if it's, I don't know, in the church or whatever? I mean, if the age difference is there, I just don't understand why college gives a license to abuse.
I think this is, we're trying to figure out how you expand position of authority, but that you don't end up with a, in college, you have oftentimes a 21-year-old and a 17-year-old. That would be a normal, college age range. And so I think we're looking at, does the committee feel it's appropriate to start criminalizing that?
Let me just do this. We've got a couple things to work out, and I think this discussion is teasing out some things that need to be fleshed a little bit more. So we're gonna hold this, and it'll be up next week, but we're gonna hold this so we can flesh out some of these issues. So continue the work group, and we'll move forward next week. Okay?
Do you want to keep it with the amendment?
Yeah, we're gonna base it off of the amended version, because that's significantly better than the original. All right, is Senator Carter here? Are we on Senator Lee, Senate Bill 20?
Senate Bill
20.
Senate Bill 20 expands statutory evidentiary provisions that authorize the admission of an out-of-court statement in a juvenile court or criminal court proceeding if the statement is made by a child victim under certain circumstances, including a statement made by a child victim who's younger than age 13 and is the alleged victim or the child alleged to be in need of assistance, a case before court concerning neglect of a minor, and a statement made by a child victim who is younger than 13, who is an alleged victim or witness in a case before court concerning a crime of violence under 14-101 of the criminal law article. There is one amendment in your packet. It is technical and goes through the statute to in instances where the statute provided for a child victim, it also specifies or witness to conform with the new requirement or new authorization to for these statements pertaining to children who are either victims or witnesses of crimes of violence.
All right, Senator Lee.
It's what they call the tender years doctrine. The reason why you have this, it's just expanding it to neglect of a minor, criminal neglect. And also, we're in a situation where the alleged victim was under 13 years of age and they were a victim, or they were witness and they're under 13 years of age to a crime of violence. It doesn't include second-degree assault, but includes those things that are listed under crimes of violence. The reasons they brought this is because very often these young victims, you want to be able to create a safe environment when they witness something, or if they give a statement to a trusted individual that's listed already in current law, close in time when the crime committed, was committed, and also it creates greater reliability when you're trying to prosecute these cases. So that's why we offer this, and so. Bit more compact and more.
I mean, just for everyone, I mean, look, it feels weird because it's like you're creating this new exception and you have hearsay for a reason, but just for people to feel a little bit better, just have counsel just read the page 3 lines, whatever, 12 on, that shows the kind of the test that the statement has to go through before it's admitted.
I guess just looking at what you said, Mr. Chairman, on 3 line 12, the existing statute provides that in a Senate proceeding, juvenile court proceeding, that would be Senate or juvenile court proceedings, an out-of-court statement by a child victim may come into evidence to prove the truth of the matter asserted in the statement if the statement is not admissible under any other hearsay exception and regardless of whether the child victim testifies. But actually, I think what you were getting at was the sort of the process or procedure that they would need to go through. So the court basically evaluates if for the admissibility of the statement, if the statement has particularized guarantees of trustworthiness. So in determining that, and this is page 4, and if you're looking at the reprint, it would be bill page 4 of 6 in the reprint. So provide starting at line 12, to determine whether the statement has particularized guarantees of trustworthiness under this section, a court shall consider, but is not limited to the following factors: the victim's or witness's personal knowledge, the certainty that the statement was made, any apparent motive to fabricate or exhibit partiality by the child or victim witness, including interest bias, corruption, or coercion, whether the statement was spontaneous or directly responsive to questions, timing of the statement, whether the child victim's or witness's young age makes it unlikely that the victim or witness fabricated the statement that represents a graphic, detailed account beyond the child victim's or witness's expected knowledge and experience. It goes on.
So people get it. I mean,
yeah.
but all right. So let's adopt the amendment. Motion to adopt the amendment. Everyone's fine with that? All right. Now it's before you as amended. Further discussion. Senator Castley.
I'm just trying, so we were looking a second ago on page 3, right? So if we adopt these changes on page 2 of the reprint, then you come over to page 3, and it says, out of court statement, they come into evidence in a criminal proceeding, other than SINA, to prove the truth of matters if the statement is not admissible under any, and the child testifies. Okay. All right. I'm sorry. I was just thinking through it. So the child testifies, and it's and then in a SINA, child doesn't have to testify. So you would just have you would only have the out of court statement. I don't do any SINA, so I have no idea if that's reprehensible or not. But the criminal part makes sense, I guess.
Senator West, you want to say? All right. Further discussion. All right. Motions for favorable.
As amended.
As amended. It's been seconded.
Second.
Is everyone okay? All right. Great. We've done 317, right? 317 we did.
Yeah, we did 317, we have 331.
Let's do, okay, Senate Bill 331.
Senate Bill 331 repeals the termination date for a pilot program for preventing HIV infection for rape victims and establishes the program as permanent. The bill further repeals an annual limit of $750,000 that may be paid to physicians, qualified healthcare providers, and hospitals from the CICB. The Governor's Office of Crime Prevention, Youth and Victim Services must file a report December 1st, 2022, and every 2 years thereafter on the operation and results of the program during the immediately preceding 2-year period.
All right, discussion. Yeah, we got the letter from, do we have to get anything from B&T on that?
Right, B&T approved.
Okay, so B&T is approved. All right, then motion for favorable, it's been seconded. Everyone's good? Okay, great. Have we done 371 yet? Did we do that?
No, we did not.
Let's do 371 and then we'll do 450.
So Senate Bill 371, this bill repeals the authorization for county commissioners of Carroll County to conduct a criminal history records check on current or prospective county employees. So instead, the bill authorizes the Department of Human Resources of Carroll County to request from CJIS, Central Repository, a state and national CHRC for a prospective county employee or volunteer. So the big thing is that it's including volunteers, which are currently not covered under the law.
It's been seconded. All right, everyone's good. All right, we'll go to Senate Bill 450.
So Senate Bill 450, this bill alters the definition of harassment and sexual harassment. It's based on the bill as passed by the Senate last year. It's identical to the bill passed by the Senate last year. The bill repeals the current judicially determined meaning of harassment and redefines it as offensive, as unwelcome and offensive conduct which need not be severe or pervasive when the conduct is based on the person's status in a protected class. So submission to the conduct is made either explicitly or implicitly a term or condition of employment for the individual. Submission or rejection of the conduct is used as basis for employment decisions affecting the individual. And 3, based on the totality of the circumstances, the conduct unreasonably creates a working environment that a reasonable person would perceive to be abusive or hostile. The bill also mirrors this definition with sexual harassment, but the conduct consists of unwelcome sexual advances, requests of sexual favors, or other conduct of a sexual nature. Do you want to see if people have issue with?
Favorable? Seconded. Everyone's okay? Okay. Great. All right, now we'll go into Senate Bill 18.
Oh, gotcha. So Senate Bill 18, this bill alters the definition of local government under the Local Government Tort Claims Act to include the Cambridge Waterfront Development, Inc. in Dorchester County. So in 2018, the Cambridge City Council and Dorchester County Council formed CWDI, a nonprofit corporation responsible for the comprehensive planning and mixed-use redevelopment of properties along the Cambridge waterfront.
Say it again.
I'm not sure why this was assigned to our committee, but I'm in favor of it.
Yeah, local tort claims.
Okay.
So the effect of altering the definition of local government to include CWDI would mean that CWDI would be subject to the Local Tort Claim Act. So the liability would be capped at $400,000 per individual claim and $800,000 per total claim. For a claim that arises from the same occurrence for damages from tortious acts or commissions. Yes.
Motions were favorable and seconded, everyone's fine. All right, so there are two bills left. Both of which need a certain, well, we've got a little bathroom break here, so let's just take a 2-second pause. We're missing two senators who've gone for bathroom breaks. I need everyone here for this discussion. So we'll take a 2-minute pause for bathroom break, make sure they get back, and then we're gonna go right into this.
I mean, you could.
All right, we're back with Senate Bill 151. Can we get Jamie on the camera?
Senate Bill 151 clarifies that it is a hate crime for a person to make a false statement to be made, or excuse me, a hate crime for a person to make or cause a false statement to be made to a law enforcement officer in violation of Section 9501 of the criminal law article about a group or person when the person's actions were motivated in whole or in substantial part by the subject of the statement's race, color, religious beliefs, sexual orientation, gender identity, disability, national origin, or homeless status. Violators are guilty of a misdemeanor punishable by imprisonment for up to 3 years and/or a $5,000 maximum fine. There is one amendment in the voting packet. The amendment is largely technical or stylistic, but it would provide specificity saying this is amendment number 363228/1, would provide clarifying language that it applies to a statement, report, or complaint to a law enforcement officer about a person or group that the person knows to be false in whole or material part in violation of 9501 of the criminal law article. The new language is being added, mirroring the language that is in, or better mirroring the language that is in 9501. I don't know that there's a real difference as far as interpretation goes about it, but it is clarifying that it doesn't just apply to a statement, it also applies to reports or complaints to law enforcement, and also that the person would have needed to have known that the statement, report, or complaint was false in whole or material part. Regardless, it still requires a violation of 9501. Which the language for that is laid out in the bill on page 1, starting at line 19.
Senator Carter, then Senator Castle.
Thank you. I just wanted to say that I agree with the amendment. The amendment absolutely makes the bill, a better read, so thank you.
So I have no problem with the bill where we're going, but just that what we did in the clarifications was we took part of 9501 and copied it in the bill, in the amendment, but not the rest of it. I think it should be either all in or all out. We could get away with just saying make or cause to be made a statement, report, or complaint in violation of 9501, or if we're going to bring I have no problem either way, but we split the baby here, and that makes it unclear. We either go all in or all out. I mean, if Senator Carter would like it all, I'm fine with it all in. Jill, I'm just saying that we copied most of 9501, but we left out the part that says with the intent to deceive, to cause an investigation, et cetera. We left that out. So if we're going to copy part of 9501, if we're going to bring 9501 in, we should bring all the language in, and not just a piece. But
So the language doesn't bother me.
okay, so you want to just bring it all in then?
Well, I'm not looking at it. Read exactly what it does.
So Jamie can read it right now.
Well, so I guess the option that Senator Cassidy mentioned would be, that you could leave in that it's a statement, report, or complaint to a law enforcement officer. But then basically strike what's there up to in violation of 9501. So you're making clear, one, that it applies to all of those things, a statement, report, or complaint. But instead of bringing only some of the language in from 9501, you're just saying it's a violation of 9501, just to remove any ambiguity that maybe you're removing intent language or anything like that, that you're just linking this to a violation of 9501 that is motivated.
But if Senator Carter would rather have the 9501 language in, then we should bring all the 9501 language in and not cut part of it off. So to me, it's your purpose, whatever you would rather have. Right now, split the baby, we brought part of the language in. Either leave it out, leave it all out, or bring it all in. That's my only point. I don't care.
A problem with bringing it all in. Unfortunately, I'm having laptop trouble, so I'm unable to bring this specifically up right now. So if you could just read the whole thing as it would read, it'd be helpful.
I mean, 9501, the part that we left out of the amendment says, with the intent to deceive and to cause an investigation or other action to be taken as a result of the statement, report, or complaint. So
Okay.
either bring that in to the amendment, or just truncate the whole thing and say violation of 9501.
I am okay with either of those choices.
Why don't you just, you could do Jamie a favor and just do the
Just
9501.
truncate it then.
Just say 9501.
Right, so.
It's
what's
an
the
easy
language?
drafting.
So now it would
Mark
say,
Meady doesn't
make
care.
or cause to be made a statement, report, or complaint to a law enforcement officer in violation of 9501. Right, Jamie?
Again, Senator?
Make or cause to be made a statement, report, or complaint to a law enforcement officer in violation of 9501. Would you have to have about that person or group?
That would be truncated. Well, right, that's in the lead-in language, is that it's about the person
Or group in violation of 9501, right? And then strike out,
because they would be the, right, the victim in that.
okay. So you leave that part in?
Well, yeah, I would say about that person or group.
Okay, and then truncate it there, and then in violation of 9501. Right, so you delete that the person knows to be false in whole or in part, material part. It's just in violation.
That's implied by,
But we're striking that
the,
language
the,
out, 'cause it's
right,
in 9501.
because that is 9501.
Right.
Senator Carter.
That's fine with me. Sounds fine. Can't read it because I couldn't see it on my computer, but it sounds fine.
So can I speak up for the alternative? I think it's important that we be very clear what we're doing here and don't accidentally imply to our constituents that that they should hesitate in calling, that the offense here is when you know the report to be false. And so my preference is to repeat the statute as a belt and suspenders thing, as opposed to what I acknowledge is a cleaner version with the cross-reference, because we're telling the court the same factors that apply in the underlying crime repeat when this is done in a racially malicious way. So that would be my preference, to the extent that the sponsor is ambivalent about it. I think we.
Good, I'm just being like, I don't know, maybe it's the lack of coffee, I'm not sure. But the bill already read exactly that, so I'm not sure, what are we changing? I'm reading the bill. I don't have it. Oh, that's not it. I'm having trouble pulling stuff up, so. Oh, it's here? Okay.
Wait, I got it. Is this 151? Here it is.
Thanks. Amendment that specifies the report, complaint, whatever, and I agree with, if you're saying to use the original language in violation of 9501, I think that's cleaner as well. Is that what everybody's saying? Yeah. Yeah, I agree with that.
Aforementioned statute, yeah, so that you have, so that it's very clear to the courts that this is something that you're knowingly doing. It's just a clear message you're sending. I don't think functionally it really changes anything.
I don't think
It doesn't
it's
functionally change
necessary to make that clarification, because I trust the court to know the law or learn the law if something's before them. However, if it's your pleasure, it doesn't bother me.
What do you all want to do? I mean,
I'll second Senator Walsh-Reicher's motion. Just repeat the language in there.
Okay.
And drop it back in. I mean, they are in two, one's in 9 and one's in 10, so it makes
Yeah.
it easier to have it all, it's right there. I second his motion for that amendment.
Just technical clarification.
Yeah.
That's good.
good.
So, just going back to 9501, would we not only say that it's to a law enforcement officer, but also add in that language of the state, a county, municipal corporation, or other political subdivision, as well as Maryland National Capital Park and Planning Police, with the intent to deceive and cause an investigation or other action to be taken.
I think you're dropping the
so it's
entire
all,
thing.
the entire thing goes in. Okay.
Yes.
Gotcha. Okay.
More ink. It's okay. It changes nothing functionally, so. Okay, can we adopt that amendment? Everyone's good with that? Great. The motion for the bill is for favorable.
With amendment.
With amendment. Seconded, everyone's good? Excellent, all right. Now, the main event. Senate Bill 33. We'll go to council, then we'll go to the Senator Lee.
So Senate Bill 33 repeals the exemption from prosecution for specified sexual crimes if at the time of those crimes the person was the victim's legal spouse. In short, put a different way, it repeals the spousal exemption from prosecution.
I would urge my colleagues to vote favorable on this bill as it was introduced, the way, because under the current law, married couples now have less protection than unmarried couples if you live together and you commit a sex crime. I think this is just about protecting and respecting the institution of marriage. I've been married for over 30 years, and I think that individuals in a marital situation should have the same rights as individuals who are not married or cohabiting. I think it respects marriage, which is an institution that respects love and mutual trust and respect between two individuals that have decided to have a life together. And I would resist any amendments, but just get the bill out clean. I know there is an amendment introduced by my esteemed colleague, Senator Huff, to define what is consent, but if we do that, I think we're creating a new law dealing with what constitutes consent for both married and unmarried couples. And I think that deserves a different bill and a full hearing so that all the stakeholders can come in and provide their input on that issue. If you have an issue with fourth-degree sexual assault, let's have a different bill and a full hearing on that if you want to repeal that. I think that has been the stickler with this bill, is fourth-degree sexual assault. But as the prosecutors and the state's attorneys who came in they have told us that it's a lot harder to prove fourth-degree sexual assault than it is just plain old assault. Because for fourth-degree sexual assault, you have to prove beyond a reasonable doubt, and it's only up to a 1-year penalty. Whereas simple assault, you just have to prove that it happened, and that's up to 10 years. So they would rather just go for the assault rather than doing a frivolous complaint about fourth-degree sexual assault. So I urge my colleagues to vote for this bill as it came in.
All right, well said, Senator Lee. Just further discussion, Senator Huff.
Yeah, I'm not opposing the bill, but I have a clarifying amendment. It's the same amendment that this committee wisely put on last year. And just to go back in what we're talking about in this legislation, under Maryland law right now, only first-degree and second-degree rape can be charged between married couples. The bill seeks to bring in third-degree and fourth-degree sex offenses. There's never been any quarrel in this committee about third-degree rape. We had testimony, I think, the first year that this came in, where a woman came in who was intoxicated and terrible circumstances. And so the issue has been fourth degree. And for a long time, this General Assembly has struggled with fourth degree. And just to explain to people what that means, fourth degree sex offenses were created because we did not, the elements are, with all due respect, the elements and what has to be proved are exactly the same as second-degree assault. But the General Assembly, and actually the federal government came in and asked us for new guidelines on sex assaults. I think that's why we did it a couple years ago. But the point of fourth degree was that if somebody goes up on, let's say, a metro and grabs, a guy goes up and grabs a woman in an intimate area, you did not just want to charge a second-degree assault. You wanted to be able to charge a fourth degree because you wanted a clear red line to say this person was a sex offender, and you wanted the public to know. And a fourth degree requires sex offense registry. So the point was that when a stranger came up and grabbed someone or did something, you wanted it known to all that the person wasn't just a second-degree assault, it was a sex offense. So then we have this bill in front of us, which would take married couples, and remember, the law does not require, and this amendment does not change consent with all due respect. The law does not require for a fourth degree, if I walk up and grab you, that's it, that's a fourth degree. It does not require consent, nor should it. The problem that we are doing when you have intimate partners, where in a routine part of their relationship there would be intimate touching, and you are making that part of the law analogous to strangers out on the street, you are creating a problem. And so I think the amendment was very artfully drawn up only to this section, does not change the consent law whatsoever, but it just simply says, only in the case of two individuals engaged in ongoing consensual sexual relationship, physical contact commonly engaged by the two individuals in a sexual relationship, unless the individual has reasonably indicated to the other that further physical contact is unwanted. So if you pass this as is without the amendment, the plain reading of the law is if a wife grabs a husband in an intimate, touches a husband in an intimate area, consent does not have to be applied one way or another, which would be routine in a intimate couple relationship, that would be eligible for a fourth degree sex offense. And the argument they will make is, well, the amendment is familiar touching or friendly affection. That is not the same. The plain reading of a fourth degree sex offense is if you touch someone in an intimate area for your own sexual arousal. That is plain and clear, and we all, in an adult, and being adults having this conversation, know in an intimate relationship that happens commonly. But on a stranger on the street touching you, that does not happen. Now, familiar touching is what our friendly affection is if you walk in and you see our old friend and you give him a hug. That is a plain it's very disrespectful for your staff, for Susan Lee to be Senator Lee sitting there shaking his head vigorously when I'm talking. You're not a... I think it's disrespectful.
All right, look. I'm not, look, Senator is able to make the argument, and, we all have to be respectful. If you're sitting there as a wallflower, you're passively observing, that's fine. But if you are making gestures, that's distracting. You gotta stop, right? So if it continues, I'm gonna ask you to leave, all right?
I think we should have a civilized availance.
Yeah.
And I think I've made my point on this, in that we can pass this, and you can do this in a way that you can still charge fourth degree, but I think that our job as legislators is to create a law that makes sense. And the other argument I've heard against this is, well, prosecutors will never charge it. First off, they can already charge a second degree. The elements are exactly the same. This is actually a lesser penalty. The only difference is it carries sex offender registry with you. But it is not our job to determine what a prosecutor will charge, could charge, should charge. Our job is to put in the law, and we must assume that a prosecutor will charge based on what we write. So, for those reasons, I'm going to introduce this amendment again because I think this is common sense, and I would love for the advocates to explain to me what you're trying to charge that this amendment does not cover. What outside of this amendment are we trying to charge? Because the fear with, if you do this amendment, divorces in these cases are very messy. Now you've created a law with a year statute of limitations where someone can come back, the abuser could come back and say, my wife, she touched me intimately 6 months ago. I'd like to charge that. It's within the year statute of limitations. It could be brought up. You could have reverse charges on each other. So I think it's a clarifying amendment. It does not change the consent law, it does not attack the bill, it just clarifies it so we produce a common sense law for people who are in ongoing relationships where intimate touching would be part of that. So that we do not confuse our law with a law that was rightfully created when a stranger walks up on the street and grabs someone on an intimate area.
So, before I'm going to get Senator Lee, I'm going to give you a chance to kind of go back and forth, but I think your argument hinges on three things. One is, what is kind of the familial exception, like the normal cadence of your relationship? And then two, what is sexual contact? What is the definition of sexual contact? And then three, I know it's separate of an element, but it's just like, hey, if a breakup, you have a messy marriage breakup or whatever, you've got a year to bring this, and it's going to get messy. I hear all three, but sexual contact, like swatting someone on the butt or like kind of even grabbing someone, I know there are a couple of elements there, but that isn't sexual contact. It's actually much more intimate. I'm not going to sit here and read what it. I know. I'm just saying.
How I explained it plainly.
Yeah, exactly right. Because I don't want to get into the details because we're on camera, but that doesn't. What you described, the sanitized version of what you described, doesn't to me fall under the definition of sexual contact. And maybe you were sanitizing it for the same reason that I'm sanitizing it.
I'm having some confusion here. So
Yeah.
I describe sexual contact as someone touching someone in an intimate area for their own sexual arousement, which I believe is essentially the definition of it.
Got it. Yeah, got it.
Which I would offer that I think that is routine in relationships with this amendment discusses. That would be a routine occurrence in a relationship. People would be touching each other in intimate areas for sexual arousal.
Yes, but then there's the permission element there that has to be.
Fourth degree does not require,
Understood.
rightfully so, any sort of
But
consent.
in our mind's eye, you're talking about. It's hard to do this without actually talking about real examples. But like if you're penetrating someone or you're doing something like that, obviously it's done for sexual arousal, and that's normal cadence of
But
an
it doesn't
interaction.
even require
But
penetration.
I
which you're
understand
talking
that.
about.
Or grope. I'm just trying to sanitize my language, but yes, I understand that. More intimate than just a mere touch on the butt or something like that. Okay, it's.
Why would it need to be more intimate than that? The whole point of fourth degree sex offense is if a guy walks up on a bus and grabs a woman by the breast, that becomes a fourth degree automatically.
But if that's a normal, that I understand is part of, that could be normal cadence or familial affection.
Yeah.
I mean, that's.
With all due respect, what you're saying is my amendment. My amendment is what you're saying, if this is the normal cadence, then you should accept my amendment. My amendment is saying exactly what you're saying. It's just clarifying exactly what you're saying.
I disagree with that.
The exact point you're making, saying if you're in a relationship with this person, and the normal cadence is that you're having intimate touching, then this amendment's not. That's exactly what you're saying. This amendment is clarifying exactly that, because the law does not. What you're saying makes perfect sense, but the law does not reflect that. This amendment is simply clarifying to exactly what you are saying. Exactly what you're saying, that the cadence of a intimate partner relationship is different than two strangers on a metro.
Senator Lee?
I disagree. I think what we're arguing here is what is the standard for consent, whether you're married or not. And to me, that's creating new law. Just as you said, Senator, you said that you wanted to get input from what the advocates think. Well, that's almost like telling us that we need a new bill, we need a hearing on this particular issue. I don't see it as a clarifying amendment at all. I see it as a new standard you're trying to create for what constitutes consent. Let me tell you what what is fourth degree and what is not. What is not is a friendly or familial affection. Okay, like if you touch a woman's breasts or guy's genitals, or, and it's, and there's no pushing away, there's no implied resistance or anything like that. Swatting on the butt, no, that's not it either. But let me tell you what has been constituted fourth degree sexual assault. A man violently shoved his hand down a woman's pants into her underwear and groping her. Okay, that's fourth degree sexual assault. The victim could not confirm that his finger penetrated her, so it was only a sexual assault that could be charged with fourth degree sexual assault. So, and this was an actual case. Another case dealing with a woman had a very difficult birth and had wounds and stitches and in her intimate areas, and she's just got home from the hospital. She's in great pain. The father touches the intimate areas, saying he's waited long enough, and that's fourth degree, okay? So I think that what you're asking for in this amendment requires a new bill and a new hearing so that everybody can come in and weigh in on it, just as you mentioned. And let me tell you, wait, stop, okay? We are one of the few states right now in the whole United States that still has spousal defense for sex crimes. And I think that Maryland has got to move into the 21st century. Maryland is not an affirmative consent state. In other words, there is no law that says you have to consent before you can do this. If someone says no, they say no, and no means they say no. There's some resistance, whether it's physical or verbal, or where the victim doesn't resist because there is a rational fear of resisting. So I think we just got to move forward with the bill as is, and go ahead and vote the way you want. If you want to vote against this bill, go right ahead. But I think it's time we move this forward. The House has passed it many times. And I just ask for my colleagues to please move forward on SB 33 as is, as it was introduced.
Yeah, I'm not arguing not to pass the bill. This is just a clarifying amendment. And with all due respect, this amendment was offered and put on by the committee last year. And so there's no reason why it couldn't have been addressed. People knew that we'd put this on last year, and we'd had concerns. We've had concerns multiple years over this same provision, and the same argument I'm making has been why this bill has not passed for multiple years. And we've tried to work and compromise on this. And with all due respect, the definition of fourth degree assault is not correct. If you grab somebody by the genitals, that's a fourth degree, plain and simple. If somebody grabs somebody by the breast, that's a fourth degree, plain and simple. That's why we created that law. And second off, and just to clarify with counsel, that this says it's drawn specifically to 3-308B1. This is only affecting the fourth degree, correct? We're not changing consent for the whole law. I'd just like the counsel to confirm that.
Right, so the amendment applies to 3-308B1, which is actually in the amendment at the very end of the amendment, just shows fourth degree, that aspect of fourth degree, which is that a person may not engage in sexual contact with another without the consent of the other.
So we're just addressing this. I'll just say I'm not speaking against the bill. I'm just speaking in favor. I think there needs to be a clarifying amendment specifically, and this is drawn specifically to the fourth degree sex offense for the reason that I mentioned above. And I think this clarifies the bill.
Last year, when this amendment was introduced onto this bill, there was no input from the stakeholders. Have they had input with you since that time? Have you outreached to them to get their input on this amendment that was tacked on last year and that you want to put forth this year? Have you had their input? I've had their input. They're not for this.
The stakeholders are every married person inside the state of Maryland, so.
No, I was just responding that the idea that people are unaware of this issue or unaware of this argument is not correct, because we've had this debate multiple years, and my point was this amendment was put on there last year. And so my argument is that we should just do what's best for the law. I know advocates can advocate different positions, but I think it's pretty clear and common understanding of the law that this amendment makes perfect sense. And I guess my question would be, What is this that you're trying to charge that this amendment would prohibit?
This is an issue that requires a new bill and a hearing where we can get the input of everyone. And you did not, I don't know if you sought out their input before the amendment was made by Senator West last year. Senator West, did you, was this? All I gotta say is I would want this to move out clean, as it has done with the House of Delegates.
So, we are getting ready to vote on something that I think is very important to each and every one of us. But the fact is, dancing around the actual acts that we're talking about, when people don't seem to understand what they are, with all due respect, Senator, touching a man's genitals is a fourth-degree sex offense, right? And you clearly said that's not. But if a man shoves his hands down a woman's pants, that is a fourth-degree sex offense. I think that we should really, when we talk about this amendment, I think we're all in favor of the idea that a third-degree sex offense should not have the spousal defense. It comes to the fourth degree. I think council should take the time. We need to fully explain to each member here what we are talking about so everybody understands what we are going to be voting on.
Thanks, Mr. Chair. You know, I really vehemently dislike issues like this because I know that there's a desire to want to end something ridiculous that should not be on the books, like a spousal defense to rape. I don't think there's anybody in this entire body that thinks that is an acceptable thing. It should have been gone. But it does truly pose some problem for me when we take fourth degree, which was always, as Senator Huff spoke about, intended to be something to address inappropriate touching from a stranger to another or a person in a position of authority to another. And really, the language of the sexual contact of intimate touching, it basically goes too far when you are speaking about married people. So Senator Huff's amendment is clarifying. I don't see where it does any damage or harm to the bill. I actually don't think the right solution is even that. I think the right solution is for us to seriously consider, and this is not this bill, and you've spoken about that, Senator Lee, removing fourth degree from intimate relationships altogether, because there's just too much room for overreach, too much room for there to be, it's to be weaponized, to be used as a tool for vendetta, or just you want to be out of a relationship. And I spoke about this last year. There are no relationships in this entire world, intimate relationships, that last for a length of time where there is not a situation where one person wants to touch and the other person does not want to be touched. But when the relationship is good, often there's more tolerance for things. But when when one person is ready to go, these things become then weaponized. And so I don't truly believe that the amendment does harm, but I fully understand your passion and your desire to pass a clean bill. Advocates for several years now have, pressured, suggested, begged for this clean bill, and they are legitimately correct when it comes to the fact that we need to not have a spousal defense for rape or any type of sex offense. It is just the truth, though, that fourth degree in this particular context goes too far without clarification. And I know that you don't agree and you don't want to hear it, but when I think about what I truly believe is right, versus the sentiment of, oh, just do this because we need to end this antiquated thing. Yes, we need to do this and end this antiquated thing, but we don't need to do an overreach. And so for those reasons, you know, I'm not torn about that I'm voting for the bill, but I honestly don't understand, just like in my bill that we just passed a few minutes ago, when we said, hey, we want this to not be subject to misinterpretation. We don't want to encompass anybody that, or have a prohibiting effect for someone to call the police. We want to clarify, we want to make sure it's well understood by our citizens, our constituents, and the courts. We didn't have a problem with that. So when it comes to this issue, I believe it's because of the extreme passion that women's groups and advocates have about this, that we don't want to ever do anything to offend them. We want to make sure that we're showing that we understand the atrocities and the egregiousness of sex abuse, and so we have to do whatever makes us look better. But I don't know that we ought to do it at the expense of what is absolutely correct. And so that's why I'm being very honest with you. I have a problem, and it's not based on any, I wish I didn't have a problem. Like, I wish that I had no problem at all, and I could just, with great ease, just pass the bill for the will of the advocates, right? But it's troubling for me, and I wanted to explain that because I'm not picking any sides here. I just want to do what's right, and I don't see the harm of clarifying language in this context. Thank you.
I'll just say, look, before, we're going to go over to Senator West, and I think Senator Costa wanted to get in, and then I thought someone else. Anyway, look, that's the type of, look, what you said is nuanced thinking, and that's the type of nuanced thinking that I think that we need to exercise here in JPR. But I mean, then the fundamental thing comes down to is which way do you want the scales to tip? And for me, it's not perfect. This bill's not perfect, but the status quo right now is just not acceptable in my opinion. And so while the solution before us is not perfect, you know, yeah. So anyway, and we'll dig more, but I want to give people time to kind of keep talking. So go ahead.
Thank you, Mr. Chair. I think we all agree that the status quo is not acceptable. All we're really debating this is this one amendment. I was really away from this for a year, basically until today, although advocates have come to me and stressed that we don't need this. But I just look at the language of the amendment, just put everything aside, just listen to what the amendment says. It says sexual conduct in the fourth degree does not include, in the case of two individuals engaged in an ongoing consensual sexual relationship, physical contact commonly engaged in by two individuals in a sexual relationship, unless one of the individuals has reasonably indicated to the other that further physical contact is unwanted. If you just read the language of the amendment, who can disagree with that? It makes every bit of sense. I offered it a year ago, and so I just got a text saying that if we pass this, it would creep into other parts of sex crimes law. Well, I feel perfectly competent to read other bills and make sure that inappropriate language doesn't creep into other parts of sex crimes law. But it seems to me that this is an appropriate amendment to deal with this particular situation, and the language of the amendment is completely unobjectionable.
Thank you. So following up with Senator West's comments, I compare the fourth degree sex language offense, like it just says sexual contact without the consent. So you didn't get consent, you walked up on the subway, you put your hand on a woman's chest, she didn't give you consent, automatically it's a violation. What the amendment says, it just reverses that. It says that now you're in an intimate relationship, you don't have to have prior consent. It's basically consent's assumed unless the person says no. Seems to make perfect sense. I mean, a lot of us are in intimate relationships, and there's sort of an assumption that if you're sitting on the couch and I walk up behind you and massage your shoulders and then go further from there, that I don't have to say, oh, by the way. But if I'm on the bus and I don't know you, I sure as hell better get consent. what concerns me about this bill is that it is, I think the chairman somebody alluded to the divorce situation. We have a strong public policy of keeping divorce in the family law article and not battling it out in the criminal courts. That if you're in a relationship, or either in either divorce situation, a protective order situation, or just a physical separation, try to take these relationships into the criminal law. And that's important. It's a good public policy. I have great fear for our law enforcement officers, both men and women, who might get tied up in this one, where they're in an intimate relationship. The other partner says that there was a unwanted touching without consent, and that, a touching without consent, and now it's a fourth-degree sex offense, and now they have issues with their weapon, with their job, with their career. So this is not just a hypothetical without serious ramifications when we go here. I think this is a serious matter. Thank you.
I heard all these arguments, and I just cannot accept this amendment. Because it's a subject of a new bill and a full hearing with full comment from all different sides. If we're going to be fair, we need to have this presided over in another bill with a full hearing, so we can hear from everyone. That's all I got to say. If you want to vote, go ahead.
No. Senator Kessler.
Law enforcement officers, we live in a state that we've got NSA, tons of people out there with security clearances. We have whole law firms that all they do is defend people in security clearance issues. Those people are all, okay, so it's a good job. But this becomes heightened because probably the majority of them are in intimate sexual relationships, and the lack of clarity that we'll be building into the law would go heavily against all of those people, and that's a lot of folks in the state like Maryland. Thank you.
So there is an amendment before the committee.
Second.
So there's been an amendment before the committee. It's been seconded. We'll roll it it's on the favorable, so we'll roll it. Roll.
Vice Chair Waldstreicher.
No on the amendment.
Senator Lee.
No.
Senator Castle.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Watson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Pass.
Senator Huff.
Yes.
Senator Carter.
Is my vote necessary?
Yes. It's a decider.
I mean,
Okay, well,
your
I'm-
vote or not your vote is going to be, yeah, possibly.
It's a decider. It's a decider.
all right. So for all the reasons I stated before, at the end of the day, I have to vote my conscience, despite how much it's going to upset people. So I'm going to have to vote yes for the amendment.
Chairman Smith.
No.
The amendment passes.
Ron, you just fucked yourself.
Favorable with amendment.
Can I?
You got a favorable in a second.
It's your prerogative to hold.
Yeah, I'm gonna hold it.
Are you holding it with or without the amendment?
Holding it. All right. All All right, that ends the voting session.